The death penalty, also known as capital punishment, is the most severe sentence a government can impose. It represents the ultimate punishment for the most heinous crimes. Throughout history, societies worldwide have grappled with the moral, ethical, and legal implications of taking a life in the name of justice. The death penalty is a deeply emotional and controversial issue, with passionate arguments for and against its use. In the United States, the death penalty has a long and complex history, dating back to the earliest colonial days. Over the centuries, the methods of execution, the legal standards for imposing capital punishment, and public opinion on the issue have all undergone significant evolution. Today, the United States stands as one of the few developed nations that continue to utilize the death penalty, sparking ongoing debate and scrutiny both domestically and internationally. This exploration delves into the multifaceted landscape of capital punishment in the United States. It examines the historical context, the legal framework, and the various arguments surrounding this controversial practice. From the early days of hanging to the modern debates surrounding lethal injection, we will trace the evolution of the death penalty and its impact on American society. Join us as we navigate the intricate web of history, law, and morality, seeking to understand the death penalty's place in the American justice system. Along the way, we'll hear the voices of those most affected by capital punishment, from the families of victims to those facing execution on death row. The roots of the death penalty in America can be traced back to European influences. Early settlers brought with them the legal precedents and practices of their homelands, including capital punishment for a wide range of offenses. In colonial America, the death penalty was a common form of punishment, imposed for crimes ranging from murder and treason to theft and witchcraft. As the nation evolved, so too did its approach to capital punishment. The U.S. Constitution, adopted in 1788, acknowledged the existence of the death penalty, but also sought to limit its application through the Eighth Amendment's prohibition against cruel and unusual punishment. This amendment has been at the heart of countless legal battles over the death penalty, with courts grappling to define the boundaries of what constitutes cruel and unusual punishment in the context of evolving societal standards. Throughout the 19th century, the United States witnessed shifts in the administration and public perception of the death penalty. Public executions, once commonplace, gradually gave way to more private methods within prison walls. The rise of the abolitionist movement brought increased scrutiny to the death penalty, raising concerns about its morality, its potential for error, and its disproportionate impact on marginalized communities. The 20th century marked a period of significant upheaval and change in the landscape of capital punishment in the United States. The Supreme Court's landmark decisions, evolving execution methods, and ongoing debates over the death penalty's constitutionality and morality have shaped the current state of capital punishment in America. In the early days of colonial America, the death penalty was a grim spectacle, often carried out in public squares to serve as a deterrent to potential offenders. Hanging was the most common method of execution, a brutal and agonizing process that often resulted in prolonged suffering. The condemned were often left hanging for hours, their bodies swaying in the wind as a stark warning to onlookers. The range of offenses punishable by death was surprisingly broad, encompassing not only murder and treason but also crimes that would be considered relatively minor today. Theft, burglary, arson, and even counterfeiting could result in a death sentence. This reflected the harsh realities of life in the colonies, where law enforcement was often rudimentary and punishment severe. As the nation transitioned from colonial rule to independence, the debate over the death penalty continued. The Founding Fathers, while acknowledging its existence, grappled with the moral and philosophical implications of capital punishment. Thomas Jefferson, a staunch advocate for individual liberties, proposed legislation to narrow the scope of the death penalty, reflecting the emerging ideals of human rights and proportionality in punishment. Despite these early attempts at reform, the death penalty remained deeply entrenched in the American legal system. Throughout the 19th century, states maintained broad discretion in imposing capital punishment, and executions continued to be carried out with disturbing regularity. However, the seeds of change had been sown, and a growing movement calling for the abolition of the death penalty began to gain momentum. The 19th century witnessed the rise of a powerful abolitionist movement, fueled by a growing belief in the sanctity of human life and the inherent cruelty of capital punishment. Reformers, inspired by religious teachings and Enlightenment ideals, condemned the death penalty as a barbaric practice that ran counter to the principles of a just and compassionate society. One of the most prominent figures in the abolitionist movement was Benjamin Rush, a physician, writer, and signer of the Declaration of Independence. Rush argued that the death penalty was not only inhumane, but also counterproductive, as it failed to deter crime and fostered a culture of violence. His writings and speeches helped to galvanize public opinion against capital punishment. Abolitionists faced an uphill battle in their quest to end capital punishment. Proponents of the death penalty argued that it was a necessary tool for maintaining order, deterring crime, and exacting retribution for the most heinous offenses. They often cited biblical passages such as an eye for an eye to justify the taking of a life for a life. Despite facing considerable opposition, the abolitionist movement achieved some notable successes. Several states, beginning with Michigan in 1846, abolished the death penalty outright, while others adopted reforms aimed at limiting its application. These early victories, though limited in scope, demonstrated the growing strength of the movement and paved the way for future challenges to capital punishment in America. The 20th century ushered in an era of significant change and upheaval in the realm of capital punishment in the United States. The nation grappled with the legacy of slavery and Jim Crow, the rise of organized crime, and the horrors of 2 world wars, all of which influenced societal attitudes towards crime and punishment. The early decades of the century saw a resurgence in the use of the death penalty, driven in part by a wave of sensationalized crimes and a growing fear of social unrest. Public executions, though increasingly rare, continued to be carried out in some states, serving as grim reminders of the ultimate punishment that awaited those convicted of capital offenses. However, the mid-20th century marked a turning point in the debate over the death penalty in America. The civil rights movement, with its emphasis on equality and justice for all, brought renewed scrutiny to the racial disparities inherent in the application of capital punishment. Studies began to reveal that black defendants were far more likely to be sentenced to death than their white counterparts, particularly in cases involving white victims. These revelations sparked outrage and fueled a growing movement to abolish the death penalty, not only on moral grounds but also due to its discriminatory application. The Supreme Court, increasingly influenced by evolving societal norms and a growing awareness of the death penalty's flaws, began to issue landmark rulings that would reshape the landscape of capital punishment in the United States. As of 2024, the United States remains a nation deeply divided on the issue of capital punishment. While support for the death penalty has waned in recent decades, it still retains a significant hold on the American psyche, particularly in certain regions and among certain demographics. The death penalty continues to be a subject of intense debate, with passionate voices on both sides of the issue. Currently, 27 states, along with the federal government and the military, retain the death penalty as a legal form of punishment. This patchwork of laws reflects the complex and often contradictory views on capital punishment that exist across the nation. States that have abolished the death penalty have done so for a variety of reasons, including concerns about wrongful convictions, racial bias, and the lack of a deterrent effect. The number of executions carried out each year in the United States has steadily declined in recent years, reflecting a growing reluctance to impose the ultimate punishment. This trend can be attributed to a number of factors, including increased scrutiny of death penalty cases, the availability of alternative sentences like life without parole, and a growing awareness of the risks of executing innocent people. Despite this decline in executions, thousands of individuals remain on death row across the country, living in a state of legal limbo as they await their fate. The appeals process for death penalty cases is notoriously lengthy and complex, often dragging on for years or even decades. This prolonged uncertainty takes a heavy toll on those condemned to die, as well as their families and loved ones. Over the course of American history, the methods of execution have undergone a gruesome evolution, reflecting a constant search for methods deemed more humane and less cruel. The early days of public hangings, often poorly executed and resulting in prolonged suffering, gave way to more private and supposedly less barbaric methods. The late 19th century saw the introduction of the electric chair, hailed by some as a more modern and humane alternative to hanging. However, the electric chair's gruesome history, marked by botched executions and horrific scenes of burning flesh, quickly dispelled any notion of it being a painless or dignified way to die. In the 20th century, the gas chamber emerged as another method of execution, intended to be a more efficient and less visibly disturbing alternative to electrocution. However, the use of cyanide gas, with its horrifying associations with Nazi death camps, proved to be deeply unsettling to many, and its use was eventually discontinued in most states. Today, lethal injection is the most common method of execution in the United States, touted as a more humane and medically controlled way to carry out the death penalty. However, even lethal injection has been plagued by controversy, with concerns about the availability of the drugs used, the qualifications of those administering them, and the potential for excruciating pain if the procedure is not carried out properly. Section 3. A patchwork of laws, state-by-state variations. The death penalty in the United States operates under a complex and often confusing patchwork of laws, with each state that retains capital punishment having its own set of statutes and procedures. This lack of uniformity has led to significant variations in the application of the death penalty, raising concerns about fairness, equity, and the potential for arbitrariness. One area of variation lies in the types of crimes that are eligible for the death penalty. While all states with the death penalty allow for its imposition in cases of aggravated murder, the definition of what constitutes aggravating factors can vary widely. This can lead to situations where a crime that is eligible for the death penalty in one state might not be in another, even if the circumstances of the crime are similar. States also differ in their methods of execution, with some offering condemned prisoners a choice between methods, while others mandate a single method. This has led to legal challenges and delays as prisoners argue that certain methods constitute cruel and unusual punishment, further complicating the already lengthy and expensive process of carrying out a death sentence. The minimum age at which a person can be sentenced to death also varies by state, as does the availability of life without the possibility of parole as an alternative sentence. These variations reflect the ongoing debate over the appropriate use of the death penalty and the challenges in crafting a system that is both just and consistent. Table of Contents, Part 4, Act 3, about 3 sections. 1. Seeds of Doubt, Wrongful Convictions and the Death Penalty. 2. A Nation Rethinks Evolving Public Opinion and Legislative Reforms. 3. The Quest for Alternatives, Life Without Parole and Shifting Priorities. Section 1. Seeds of Doubt, Wrongful Convictions and the Death Penalty. As the 20th century progressed, a growing unease began to settle around the death penalty, fueled in part by a series of high-profile cases involving wrongful convictions. The irreversible nature of capital punishment took on a chilling new dimension as evidence emerged that innocent people had been sentenced to death, some even coming within days or hours of execution before their sentences were overturned. Advances in DNA technology played a pivotal role in exposing these miscarriages of justice. DNA testing, unavailable in the early days of many death penalty convictions, provided a powerful new tool for exonerating the wrongly accused. Cases like that of Kirk Bloodsworth, the first person sentenced to death in the United States to be exonerated by DNA evidence, shook public confidence in the infallibility of the justice system. These exonerations revealed a deeply troubling pattern of systemic flaws within the criminal justice system, including eyewitness misidentification, false confessions coerced under duress, prosecutorial misconduct, and inadequate legal representation for indigent defendants. The realization that innocent people could be sentenced to death, not due to malice but rather a confluence of human error and systemic failures, cast a long shadow over the death penalty. The Innocence Project, founded in 1992, emerged as a leading force in the fight to exonerate wrongly convicted individuals, particularly those facing the death penalty. The organization's tireless work, utilizing DNA evidence and advocating for criminal justice reforms, brought to light the stories of numerous individuals who had been wrongfully convicted and sentenced to death, shining a bright light on the fallibility of the justice system and the unacceptable risk of executing the innocent. Section 2. A nation rethinks evolving public opinion and legislative reforms. The growing awareness of wrongful convictions, coupled with concerns about racial bias and the lack of a proven deterrent effect, contributed to a gradual but significant shift in public opinion regarding the death penalty. Polls began to reflect a decline in support for capital punishment, with a growing number of Americans expressing reservations about its use or favoring alternative sentences. This shift in public sentiment was mirrored in legislative halls across the country. States began to reconsider their stance on the death penalty, with some enacting moratoriums on executions while others went further, abolishing capital punishment outright. This wave of reforms reflected a growing recognition of the moral, ethical, and practical concerns surrounding the death penalty. While some states moved away from the death penalty, others sought to address its perceived flaws through legislative reforms. These reforms aimed to ensure a more fair and equitable application of capital punishment, addressing issues such as racial disparities in sentencing, the quality of legal representation, and the use of DNA evidence. Despite these efforts, the death penalty remained a deeply divisive issue, with passionate advocates on both sides continuing to engage in heated debates. The battle lines were drawn between those who viewed capital punishment as a just and necessary response to the most heinous crimes, and those who condemned it as a barbaric and morally indefensible practice. As the debate over the death penalty raged on, a growing consensus emerged around the need for viable alternatives to capital punishment. Life without the possibility of parole, once a relatively rare sentence, gained increasing acceptance as a way to punish the most serious crimes while avoiding the irreversible consequences of the death penalty. Proponents of life without parole argued that it provided a just and effective alternative to the death penalty, ensuring that those who committed the most serious crimes would never again pose a threat to society, while also eliminating the risk of executing an innocent person. This sentence, they argued, accomplished the goals of punishment, deterrence, and incapacitation without resorting to the taking of a life. The growing acceptance of life without parole as a viable alternative to the death penalty coincided with a broader shift in criminal justice priorities. Policymakers and the public alike began to focus on issues such as crime prevention, rehabilitation, and reintegration, recognizing that a purely punitive approach to criminal justice was not only morally questionable, but also ineffective in achieving long-term reductions in crime. This shift in priorities, coupled with the ongoing debate over the death penalty's morality, efficacy, and fairness, set the stage for continued scrutiny and reform of capital punishment in the United States. As the nation grappled with its complex history of crime and punishment, the future of the death penalty remained uncertain, its fate hanging in the balance between deeply held beliefs and evolving societal values. The Supreme Court, as the ultimate arbiter of the U.S. Constitution, has played a pivotal role in shaping the landscape of capital punishment in America. Its landmark rulings on the death penalty have established legal precedents, struck down unconstitutional practices, and guided the evolution of capital punishment law, reflecting the complex and often contentious debate surrounding this ultimate punishment. The court's involvement in death penalty cases dates back to the early days of the Republic, with rulings often reflecting the prevailing societal norms and legal interpretations of the time. However, it was in the latter half of the 20th century that the court began to take a more active role in scrutinizing the death penalty, issuing a series of decisions that would profoundly impact its application and future. These landmark rulings have addressed a wide range of issues related to the death penalty, including the constitutionality of specific execution methods, the types of crimes eligible for capital punishment, the rights of defendants facing a death sentence, and the role of mitigating factors in sentencing. Each decision has added a new layer of complexity to the already intricate web of death penalty law, sparking both praise and condemnation from those on both sides of the issue. The court's interpretations of the Eighth Amendment's prohibition against cruel and unusual punishment have been particularly significant in shaping the death penalty debate. Through its rulings, the court has sought to define the boundaries of what constitutes cruel and unusual punishment in the context of evolving societal standards, grappling with the fundamental question of whether the death penalty, in any form, can be reconciled with the evolving moral and ethical compass of the nation. The year 1972 marked a turning point in the history of capital punishment in the United States, with the Supreme Court's landmark ruling in Furman v. Georgia. In this case, the court declared existing death penalty statutes unconstitutional, effectively halting executions nationwide and forcing states to reevaluate their approach to capital punishment. The court's decision in Furman was not a resounding condemnation of the death penalty itself. Rather, it focused on the arbitrary and capricious nature in which it was being applied. The justices found that the lack of clear and consistent standards for imposing the death penalty resulted in a system where race, geography, and even the personal biases of jurors could influence who lived and who died. The Furman decision sent shockwaves through the legal system and ignited a firestorm of debate across the nation. Supporters of the death penalty decried the ruling as an unwarranted intrusion on states' rights and a dangerous impediment to justice, while opponents hailed it as a victory for human rights and a necessary step towards abolishing capital punishment altogether. In the wake of Furman, states scrambled to revise their death penalty statutes in an attempt to address the court's concerns and reinstate capital punishment. This led to a wave of legislative activity, with states adopting a variety of approaches, including mandatory death sentences for certain crimes and bifurcated trials, where guilt and sentencing are determined in separate proceedings. Since Furman, the Supreme Court has continued to grapple with the complexities of the death penalty, issuing rulings that reflect the evolving standards of decency that mark the progress of a maturing society. The court has recognized that the Eighth Amendment's prohibition against cruel and unusual punishment is not static, but rather must be interpreted in light of contemporary values and evolving societal norms. In a series of cases, the court has struck down death sentences for certain categories of offenders, deeming them disproportionate to the crime committed or inconsistent with evolving standards of decency. For example, the court has prohibited the execution of intellectually disabled individuals, recognizing their diminished culpability and the heightened risk of wrongful conviction in such cases. The court has also ruled against the death penalty for juveniles, acknowledging the developmental immaturity of young offenders and their greater capacity for rehabilitation. These rulings reflect a growing recognition that the death penalty should be reserved for the worst of the worst offenders, and that its application should be guided by principles of proportionality, fairness, and human dignity. Despite these rulings, the court has stopped short of declaring the death penalty unconstitutional in all circumstances. It has continued to uphold the constitutionality of lethal injection, the most common method of execution in the United States, while leaving open the possibility of challenging specific protocols or practices that might render the procedure cruel and unusual in practice. The court's rulings have left the door open for further litigation and debate as society continues to grapple with the moral, ethical, and legal implications of capital punishment in the 21st century. The debate over the death penalty in the United States is often portrayed as a stark clash between two opposing viewpoints: those who believe that some crimes are so heinous that only the ultimate punishment will suffice, and those who view capital punishment as a barbaric relic of a bygone era. Proponents of the death penalty often cite a combination of retribution, deterrence, and closure as justifications for its continued use. For many, the death penalty represents a deeply held belief in the principle of retribution, the idea that those who commit the most horrific crimes deserve to be punished in a manner commensurate with their deeds. It is seen as a way to restore a sense of balance and justice to a world shaken by unspeakable acts of violence. Supporters argue that anything less than the death penalty for certain crimes diminishes the value of human life and fails to acknowledge the full measure of suffering inflicted upon victims and their families. Beyond retribution, proponents of the death penalty often cite its deterrent effect as a key justification for its use. They argue that the fear of execution serves as a powerful deterrent to potential murderers, preventing them from committing heinous crimes and ultimately saving innocent lives. While studies on the deterrent effect of the death penalty have yielded mixed results, supporters point to anecdotal evidence and a belief that even if it deters a small number of murders, its use is justified. Closure for the families of victims is another frequently cited argument in favor of the death penalty. For those who have lost loved ones in the most brutal and senseless ways, the execution of the perpetrator can bring a sense of finality, allowing them to move forward with their lives without the constant burden of knowing that their loved one's killer is still alive. Supporters argue that while the death penalty cannot bring back the victims, it can offer a measure of peace and solace to those left behind, allowing them to begin the long and painful process of healing. Those who oppose the death penalty do so on a variety of grounds, citing moral, ethical, and practical concerns that they believe render capital punishment incompatible with the values of a just and compassionate society. For abolitionists, the death penalty represents a fundamental violation of the sanctity of human life and an unacceptable risk of executing the innocent. At its core, the abolitionist argument rests on the belief that taking a life, even as punishment for the most heinous crimes, is morally wrong. Opponents of the death penalty often cite religious teachings, philosophical principles, or a fundamental belief in the inherent dignity of all human beings as the foundation for their stance. They argue that no government, regardless of its authority, has the moral right to take a life, and that doing so diminishes us all. The risk of executing an innocent person is a particularly potent argument against the death penalty. The history of capital punishment in the United States is replete with cases of wrongful convictions, some overturned only hours before execution. Abolitionists argue that even a single innocent person put to death is one too many, and that the fallibility of the justice system makes the risk of executing the innocent an unacceptable gamble. Beyond the moral and ethical concerns, opponents of the death penalty point to practical considerations that they believe render it an ineffective and counterproductive form of punishment. They argue that the death penalty does not deter crime, that it is disproportionately applied to marginalized communities, and that the resources spent on pursuing capital punishment cases could be better allocated to crime prevention, victim support, and other social programs that address the root causes of crime. As the United States navigates the complexities of the 21st century, the death penalty remains a subject of intense debate, its future uncertain and its place in a just and compassionate society far from settled. Public opinion, once solidly behind capital punishment, has softened in recent decades, influenced in part by high-profile cases of wrongful conviction, concerns about racial disparities in its application, and a growing awareness of the moral and ethical dilemmas it poses. The steady decline in the number of executions carried out each year, coupled with a growing number of states abolishing or imposing moratoriums on the death penalty, suggests a potential turning point in the nation's relationship with capital punishment. This shift reflects a growing recognition that the death penalty, even in its most carefully regulated form, carries with it an unacceptable risk of irreversible error, and that its use may be fundamentally at odds with evolving societal values. However, despite these trends, the death penalty remains deeply entrenched in the legal and social fabric of many states, supported by those who believe it serves as a just punishment for the most heinous crimes, deters future violence, and brings closure to the families of victims. The debate over the death penalty is unlikely to be resolved anytime soon, as it goes to the heart of deeply held beliefs about justice, morality, and the role of government in taking a life. The future of the death penalty in the United States will likely be shaped by a confluence of factors, including ongoing legal challenges, evolving public opinion, and the willingness of lawmakers to engage in meaningful dialogue about alternatives to capital punishment. As the nation grapples with its complex history of crime and punishment, the question of whether the death penalty truly serves the interests of justice and reflects the values of a civilized society remains a subject of profound moral and ethical significance.